Hello, students. This is the video lecture for Chapter 7, which is about gathering information, opportunities, and obstacles. Here we go. Okay, the first point that I want to make here before I start getting into the slides is that the techniques that journalists use to gather information, none of those are explicitly covered by the First Amendment. Although in 1972, looking at my notes now, in 1972, the US Supreme Court said freedom of the press would be eviscerated without some protection for gathering information. A few years later, the court explained that the public's interest in knowing about its government is protected by the guarantee of a free press, but the protection is indirect. The Constitution itself is neither a Freedom of Information Act nor an Official Secrets Act. And we'll talk about the Freedom of Information Act in a moment here, generally known by its abbreviation FOIA. Okay, just to repeat, the courts have ruled that there is no explicit news gathering right in the Constitution. We do have rights of access to administrative proceedings, any type of government organization, government agency that is having some type of meeting. If it's open to the public, people can go and report on that. However, there is a difference between access to some type of government proceeding and information related to it. Now, you can record, for the most part, you can record events that are occurring on public property. The government can put in some regulations or restrictions if they feel that the presence of journalists or the presence of a recording device might interfere with the official proceeding. There, again, from the textbook, an incident from the Maryland state legislature where reporters could come, but they couldn't record what was going on. And the court said that that was okay. Journalists could still come, but they couldn't record it. Now, when it comes to recording police activity in public, I don't think the police really like this, especially in the last few years. There's been a number of incidents where police don't really appreciate having their activities recorded, but the public does have a right to do that, especially when it's occurring, in public. There's an incident discussed in the textbook where a woman was using her cell phone to record something going on. She was still in her car recording from her cell phone. The First Amendment allowed her to do that. The government could not stop her from doing that. Now, the state of ride-alongs. Okay, a ride-along is when a journalist accompanies police officers as they are driving around a neighborhood or doing their patrols or something like that. That doesn't give the journalist any extra rights. That does not give the journalist any extra rights. Journalists don't have any more rights than any other individual when it comes to gathering information. So just be aware of that, because you're not really assisting the police. If you're a journalist doing that, you're not really assisting the police. You're just riding along for your own benefit. You're not part of the police enforcement operation. And you need permission. You still need permission to walk into someone's house. If the police walk into someone's house, you still need permission to walk into their house. Now, the courts have said that if the person does not object and remain silent, silence can be construed to be an act of consent. Okay, so in this instance, silence means consent. However, there's always some howevers in this, right? If the police are executing an actual search warrant, having a journalist accompany them could actually violate that person's Fourth Amendment. So be careful about that. Now, we have these things, they are sometimes known as sunshine laws. You like my sunshine image? Bonus points if you know where that sun comes from, if you know where the sun comes from. These are also called federal open meeting laws, federal open meeting laws. They were passed, almost 50 years ago. Anything connected to the federal branch of the government, a commission or a board that's governed by the federal branch, you have to give advance public notice of meetings, and you have to make decisions in public and record those decisions. Now, different states have different laws and different loopholes and different exemptions, so it varies from state to state. But in general, anything that the government is conducting should be done in the sunshine, as it were, in the public, and people should have the right to request information. Now, however, there is a stipulation, something known as FERPA. What does FERPA stand for? Family Educational Rights and Privacy Act of 1974, okay? The Family Educational Rights and Privacy Act 1974, typically known as FERPA. Any school that receives federal funding, which includes San Diego State, cannot release students' academic records, information about their GPA, class conduct, et cetera, et cetera. So if your parents were to contact me, this almost never happens. It almost never happens with me, thankfully. But if your parent were to contact me and say, how is my son or daughter doing in your class? I could not really talk to them because presumably you're an adult. I assume if you're taking this class, you're over the age of 18, you're an adult. I can't talk to your parents unless, maybe you're in the room and you give explicit permission, but I can't release that kind of information. So just be aware of that, that, things are public in general, but there are a lot of exemptions and loopholes. Oh, look at that, it spins. Okay, right around the same time as we had the federal open meeting laws, basically about 50 years ago, we also had the Freedom of Information Act. That anything, again, connected to the federal government, anybody, you don't have to be a journalist, you don't have to be a reporter, you don't have to be a media worker. Anybody should be able to write to the government, fill out this FOIA, again known by its acronym FOIA, to request information. And the law is that there's going to be a presumption of openness, and within 20 days you're going to get a response. However, here are the exemptions. I have them listed on the screen. You can read them or you can see them in the lecture notes. So typically what happens is, well, I don't think they usually honor the 20-day rule, but that's the law. They're supposed to honor the 20-day rule, but they could release the information and have some of it blacked out, called redacted. And they could use any of these exemptions as a reason for redacting the information. Okay, now I want to talk about the use of recording devices, which are very, very common. They've been common for many years. And now that pretty much everyone has a smartphone like this, everyone has some type of recording device with them. If you are using a recording device that's plainly visible, that's okay. You don't need to get consent. The person, if they object, they object. But if you pull it out and start recording, or if you say, hey, I'm recording, that's considered consent. You can record that. You can use that. That's totally fine. If a phone call crosses a state line, now you're involving federal law and maybe some regulations from the FCC. Once you cross a state line, okay, now you're dealing with interstate commerce issues as well. Now, when it comes to hidden recordings or recordings that aren't announced, it varies from state to state. It's a very, very ambiguous. I'm looking at my notes. 38 states allow recording with one-party consent, because the person who's doing the recording has consented. So if you're in one of these states, you could record the phone call. The other person doesn't have to know about it, but you know about it. Other states specifically outlaw that type of activity. They need two-party consent. Some states outlaw the use of hidden cameras, and federal wiretapping rules or rules against wiretapping, okay, against wiretapping, don't allow that. So some third party who's not part of the conversation cannot secretly record a phone call or secretly make a recording at all. Okay. And okay, now we have this case. This is an interesting one. I love the title list. Bart, Nikki v. Vopper. Kind of fun to say, right? Bart, Nikki v. Vopper. Okay. This case involves a third party making a recording. The people who were involved in the phone call didn't know, neither party knew. The recording is then released to media outlets, in this case, local radio stations. The radio stations air it, but the court said that was actually okay because it was a matter of public interest, okay? As with other things we've discussed, if the courts feel there is a compelling public interest in knowing this information, something that may otherwise be illegal or inappropriate is now appropriate because the public has a right to know this serious, serious matter. This was their teachers union was having some negotiations about a collective bargaining agreement, and one negotiator said, presumably he's talking about people on the other side of the negotiating table, we're going to have to go to their homes, blow off their front porches will have to do some work on some of those guys, meaning some type of violent intimidation. The Supreme Court took the side of the radio stations and the media outlets, saying that the First Amendment protects a journalist who shares or reports on an illegally intercepted private conversation when it's newsworthy and the journalist was not involved in the interception. The journalists, in this case, the radio stations, they were not the ones who did the illegal wiretapping. They just came into possession of it, okay? And because they played no part in the illegal interception, and the conversation was a matter of public concern, in this case, it was okay to use that type of recording. Here are some statutory limits to access. Trespassing, we've already talked about the state of ride-alongs. That was, what was the name of that case? What was that? That was Wilson v. Lane. Yes, of course, Wilson v. Lane. I'm going to skip talking about that. The textbook also talks about ag-gag laws, and you should be familiar with these. I think this is, again, one of those instances where something varies state by state, but just know that there are often special rules about filming or videotaping in an agricultural facility, anything that has animals, because of all the cases about animal rights, animal justice. And it doesn't seem like it should be kosher, to use that word, to ask people to sign like some sort of NDA before they walk into some area where you do not do that with other types of facilities. There was even a case where someone got in trouble for publishing photographs of cattle. I think cattle going to slaughter. You take him while he was paragliding in the air, and even that was not okay. And then we have drone laws. Now, I'm going to play some video here of drone video of San Diego State, because we really do have a very, very beautiful campus. But drone laws, it used to be kind of the Wild West. You could do whatever you wanted to, but now there's many kind of areas where they do not. And I think there's a reason the government doesn't want drones flying, interfering with, you know, commercial flight access or police activity or ambulances or something like that. But anyway, quick story. I'll try and make it quick. Several years ago, I had a student. I remember he was a French guy, like even an exchange student from France kind of thing. And he was playing around with drones. This was several years ago. And I had an assignment in another class where students had to make a video, specifically a YouTube video, and try and accumulate as many views as possible over the course of the semester. This guy made some drone video of campus that was kick-ass. He did it all himself. It was a group activity, one of those instances where one person does all the work, but he had a drone, so I'll have to give him that. Well, I knew that there were rules about flying drone over San Diego State, so I felt like I can't allow you in the competition, such as it was, this class activity, because I said it wouldn't be fair. But I remember applauding that he had that kind of video capability. Fast forward many years later, he's living in France. I saw him. I actually happened to see him. He gave me a little tour one afternoon around France. Very, very nice. Christian, thank you very much. He worked doing drone in France, which there's many rules in the US from FAA, that's, you know, aviation dealing with planes. There's many rules and licenses and stuff. Here in the States, it was so much worse in France, but there was still a need for drone activity. He worked for film videos, music videos, that kind of thing. They still want a drone video, so we figured out how to do it. Anyway, I thought that was so cool. And extra caveat, then at some point I'm contacted by someone on campus saying, hey, do you know anyone who knows drone video? We want to get good drone video of campus. None of us know how to do it. And I was thinking, yeah, I think I knew how to do it like 6 years ago, but you told me he wasn't able to do it. Anyway, that's my story. Hope that wasn't too much of a detour. Now, when it comes to fraud and misrepresentation, this is a matter of great debate. You know, I asked my colleagues who are also journalism professors about this, and there's differing opinions. Generally, it's not considered to be preferred to use deception in news gathering, to assume a fake identity, or to lie about who you are, what you are doing. Generally, it is not considered to be the best practice. People can claim you were trespassing, you were committing fraud, you violated someone's loyalty, or something like that. I am going to read a little bit. This is from this book. This is from this book, Media Ethics, okay? A Guide for Professional Conduct. And this is published by the Society for Professional Journalists Ethics Committee. Okay, all right. Here's an excerpt. This is from the New York Times. The New York Times has its own code of ethics and its own ethics rules that, very similar to what SBJ has. And here's what the New York Times says about using fake identities. Times reporters do not actively misrepresent their identity to get a story. We may sometimes remain silent on our identity and allow some assumptions to be made to observe an institution's dealings with the public, for example, or the behavior of people at a rally or police officers in a bar near the station house. But a sustained systematic deception, even a passive one, taking a job, for example, to observe a business from the inside, may be employed only after consultation between a department head and a masthead editors. Obviously, specific exceptions exist for restaurant reviewing and similar assignments. So in general, the New York Times is saying we don't want you to assume a fake identity, but maybe in some case it's okay. How's that for a very precise explanation? The most famous case, or at least the most famous case in recent memory, has to do with the Food Lion case. I think I mentioned this in a previous lecture. Years ago, ABC News, they had a primetime show. I think it was called Primetime Live even. ABC News magazine has reporters use false names and fake work histories. They made fake resumes, and they got a job at grocery stores, including access to non-public areas. And they came out with a story that Food Lion was doing horrible things like bleaching old meat to get rid of mold and slime. They would bleach the meat to get rid of the slime. And there were some unhygienic food handling practices. When the story comes out, Food Lion sues for more than $5 million in damages, saying that the reporters had misrepresented themselves in order to gain access. And they took things out of context and exaggerated and did not really present an accurate depiction. The judge reduced the award to $315,000, not $5 million, but still a lot of money. And then finally, it was reduced down to just a few dollars. So Food Lion won the case, but really nobody won. ABC only had to pay a few dollars in damages at the end, but it kind of gave them a black eye. And I think in the public made them look like kind of sleazy. So you don't want to do that. I do want to just throw in this historical example. You all know I love history. There was a famous female reporter. Her real name was Elizabeth Cochran Seaman. I didn't even know that. I had to look that up. Elizabeth Cochran Seaman. She was born 1864, became a journalist at a time when a lot of women were not journalists. She had trouble finding a job in Pittsburgh. She moves to New York. She starts writing under the name Nellie Bly, using a different name. She hears that there's a mental asylum that is mistreating people. So she manages to get herself committed to the mental asylum by pretending to be an insane woman. This was around 1893. Okay, so it's well over 100 years ago. She gets out. She has someone prearranged to come get her after 10 days. She writes an expose in the New York World called 10 Days in a Madhouse, about the horrible conditions, unhygienic, barbaric, savage conditions. The asylum is forced to do some reforms and clean up their act and start treating people a little more humanely. Now, she never would have gotten that story had she not allowed herself to be committed. So I was just saying that, journalists frown on using fake identities, but if there's no other way to get a story, maybe it's okay if there's no other way to get a story. Now, some other limits to gathering information, some other limits and some other things to be aware of. People are very, very cautious about social media, and y'all know that, y'all know that not everything on social media is true. You can't verify people's identity. So things on social media, really can't be trusted or shouldn't be trusted. Maybe it gives you a lead on something, but journalists are very wary about using information that comes from social media. There's also the issue of confidentiality. You can give someone confidentiality or use them in an anonymous source if there's no other way to get the information. But if you promise confidentiality to someone, like I'm not going to reveal your name, you really should not reveal their name. Even if there's no written contract, the journalist can still get in trouble. There's this fancy legal term from the textbook. It's not ever going to show up in average conversation, promissory estoppel. But just know that even if you don't write down or have a signed contract with someone that you're going to maintain confidentiality, you still probably should. You still probably should, because you get in trouble if you don't. Sometimes people who are not JMS majors or don't know much about journalism think that, reporters pay for information. No, reporters, reliable, good, honest, reputable reporters don't pay for information. The reason is that the information can't be trusted. If someone were to come to me and offer me money to spill dirt on the inner workings of San Diego State as a professor, been here 15 years, tell us all the dirt on San Diego State. There's no dirt. San Diego State's wonderful. I love working here. It's an awesome job. But if someone gave me money, would you trust the information that I said, like I was paid for it? And hey, I'll tell you a little bit of information for $100. You pay me $10,000. Heck, pay me $50,000. I'll give you some really juicy information. I'll make up information if you give me $50,000. So that's why people don't trust information that was paid for. Now, there is a gray area, as with everything else. There's a gray area. Those morning news shows or those daytime talk shows or something like that, like Good Morning America or something, say they want to do a story on the latest viral sensation. Some toddler has gone viral on TikTok and we've got them in the studio. Tune in tomorrow. If you call up that family, it's a toddler, you got to talk to the parents, right? You fly them to New York City, put them up in a hotel, wine and dine them at a fancy restaurant. That is a form of compensation. That is a form of compensation, but it's not as explicit and overt as, hey, we're going to pay the family $50,000. So it's kind of a gray area. And then another, because I know this happens, another news station or another program might say, hey, they're going to put you at a 4-star hotel. We're going to put you at a 5-star hotel. Don't go on Good Morning America. Come on the Today Show, So this kind of thing goes on. So don't pay for information. And the reverse is also true. You should not accept gifts. The reverse is also true. You should not accept gifts because that could taint your objectivity. Again, this presents a lot of problems when it comes to people who cover sports. Maybe they want to give you free tickets. We're going to give you great tickets. We're going to put you right next to the clubhouse. We're going to put you, right next to the dugout. We're going to put you wherever and write about how wonderful the Padres are. Well, you shouldn't really be accepting a gift like that. Entertainment reporters are particularly notorious for accepting gifts. They're not accepting money, but there's a new Jurassic Park or a new Marvel movie or whatever, and it happens to be shooting in Hawaii, and the studio says, we're going to fly all these entertainment reporters, we're going to fly them to Hawaii, put them up, in these wonderful resorts, and they get to do an interview with the cast and crew. And then they're going to go back to wherever they came from and do a little story in their hometown about, here's the new Jurassic Park movie. It's going to be a positive story, right? The studio doesn't have to tell you, give us a positive story about Jurassic Park, Part 4, Part 5, whatever they're up to, Jurassic Park, Part 6, whatever. They don't have to tell you, do a positive story. The implicit understanding is if you don't give a positive review to our movie, we are not inviting you to the next junket for the next movie, which is going to be on the Mediterranean, on a Greek island, right? We're going to fly you to Greece. That's the next movie. But if, so entertainment reporters are kind of notorious for this. So you shouldn't be accepting gifts and you shouldn't be paying people. And that's all I have for you. That's the end of the lecture. Okay. See you on the next one.